Welcome to the Moot Lecture on Law. The topic today is criminal justice administration in the pre-trial stage. Wheels of criminal justice administration start spinning with the commission of an offense. Therefore, before we enter into what the procedure for criminal justice administration is, we must understand what is an offense. An offense, in lexical terms, has many connotations, but for the purpose of this lecture, we must understand offense as we understand it under criminal law. Now, criminal law defines offense in the CRPC and in the IPC. Now, according to the IPC and the CRPC, offense is any act or omission which is made punishable by the IPC or any special law in force at that time or any local law. An offense also includes a complaint which is filed under Section 20 of the Cattle Trespass Act 1861. Now, offenses under criminal law can be categorized as cognizable offense, non-cognizable offense, summons tribal offense, warrant tribal offense. A non-cognizable offense is an offense where the police officer cannot arrest without warrant. A summons tribal offense is an offense which is punishable with imprisonment for 2 years and less. A warrant tribal offense is an offense which is punishable with imprisonment for more than 2 years. Now, when any of the above offenses are committed, the first process is to file a complaint. Now, a complaint may be filed either before the police or directly in court. When a complaint is filed before the police, it is either under Section 154 or under Section 155. And when it is filed before court, it is under Section 156(3) or under Section 200 CRPC. Now, we will consider each of these procedures separately to understand how you proceed when a complaint is either filed before the police or before the court. Now, under Section 154 CRPC, when a complaint is filed, we call it FIR, which is the First Information Report. Now, this First Information Report may either be in writing or oral. Now, when this complaint is in writing, then it is registered as an FIR. But if the complaint is oral, then there are certain duties or certain rules which must be followed by the police officer. Now, first, the police officer must note down the complaint in writing. Then, he must read over and explain the complaint to the informant. And then, he must get the signature of the complainant in the complaint which is noted down. And then, he must provide a copy of the complaint to the complainant. And most importantly, he must register the complaint in a book that is maintained for noting down such complaints. Now, if a complaint is made with regards to offenses punishable under Section 326A, 326B, or any offenses under Section 376, 354, then it is important that it must be reduced in writing either by a female police officer or by a woman officer. So this is basically how a complaint is registered in the police. Now, when a complaint is registered before the police, and if it is of the cognizable variety, that means if the complaint is of the commission of a cognizable offense, then what happens is the police officer or the police officer in charge of the police station may either decide to investigate the matter himself, or he may depute a junior or a subordinate officer to investigate the matter. Now, when he investigates the matter, there are certain aspects or certain powers and obligations and functions of a police officer that must be done during the investigation stage. Now, what is this? This is the police officer can visit the PO, he can ask the attendance of the witnesses before him, he can interrogate the witness, he can record their statement under Section 161, he can record the confessions and admissions of the accused. Then he can also get the statements of the accused, of the witnesses recorded under Section 164 CRPC before a magistrate. Now, what is very important to understand is when a police officer directs any witness or a complainant to attend before him, it must be noted that if the complainant is a female or a minor below the age of 15 or a person above the age of 65, then he may not be directed to attend any place other than his own residence or any place which is convenient to the informant. Now, another important duty of a police officer or another important function or power of a police officer during the stage of investigation is that the police officer has also the power of search and seizure. Now, what is search and seizure? Now, the procedure of search is basically governed under Section 100 of the CRPC, but what it is the police officer can go to any place where he thinks there is evidence or materials which is relevant to to prove the offense, and here he can go and search the place and seize any article which is material to prove the commission of the offense. Now, this place may either be within the jurisdiction of the police station where the offense is committed, or this place may be without the jurisdiction or outside the jurisdiction of the police station where the offense is committed. Now, very importantly, when the police officer is searching in any place which is without the jurisdiction or outside his jurisdiction, then it is important for the police officer to inform the police officer in charge of the station where the search is to be executed, and then he must require help from that police station with the deputation of an officer from that police station to search that place where he will be finding material evidence. Now, what is also important is during the period of investigation, a police officer, if there is a commission of a cognizable offense, may also arrest the accused if he finds that there are sufficient materials to proceed against the accused. Once he arrests the accused must be forwarded to the nearest magistrate having jurisdiction to take cognizance of the offense, and if the police officer considers that it is not necessary to arrest the accused, he may either release the accused in bail or a bond of his own cognizance. Now, this is where all the duties and functions of the police officers are concerned. Now, what is very important to note in this aspect is that a police officer cannot coerce or force any accused to make any admission against his own will voluntarily. Now, such admissions are not admissible in evidence under Section 24 of the Evidence Act. Now, supposing a non-cognizable offense is reported to the police as per Section 155 of the CRPC. Now, in these cases, what the police officer must do is he must send a report of this. First, he must register it as a GD, and then he must send this report to the magistrate. And until and unless the magistrate gives permission, the police officer cannot proceed with the investigation of this case. Now, when the magistrate gives the the authority or the permission to investigate the matter, then the police officer will have similar powers and functions as under section for cognizable offences. Now, this relates to the cognizable and the non-cognizable offences that are reported before the police. Now, it may so happen that the police officer, when information with regards to a cognizable offence is given to him, may not or does not register the FIR. Now, if he does not register the FIR, and if the informant is aggrieved by the non-registration of the FIR, then the informant may give in writing the substance of the offence committed to the SP of the district. Now, when the SP gets this information, he may either investigate the offence himself or again depute any other officer subordinate him to him to investigate the offence. Now, suppose the SP on receiving this information also does not investigate the offence. Then what happens? In such circumstances, the informant may come directly before the court and file a complaint or the substance of the information before the magistrate. Now, what does the magistrate do? The magistrate, after going through the complaint and on examining the complainant, if he finds that there is disclosure of commission of a cognizable offence, then he will send the complaint back to the police officer, to the police station concerned, directing that such complaint be registered as an FIR. And when such complaint is registered as an FIR, which must be registered as an FIR as per the direction of the magistrate, then the police officers will begin investigation as per the rules of the investigation rules under with regards to cognizable offences. Now, supposing the investigation is over, now what is the function of the police officer? Or what does the police officer do during the investigation process? Now, number one is he must maintain a case diary. Now, in this case diary, he must write down in details the day-to-day proceedings as it takes place while he is investigating the case. Therefore, if he goes to the PO, he must write it down. If he examines the witnesses, he must write it down. And every material collected during the investigation must be a part of this diary, which is called the case diary. Now, this case diary must be complete. And once the investigation is completed, the police officer prepares a report. Now, this report, under Section 173 of the CRPC, in common parlance, is known as the charge sheet. Now, when the charge sheet is submitted before court, the court takes cognizance of the offences that is allegedly committed by the offender and then proceeds the trial stage. But what is necessary to be contained in the charge sheet? Now, the charge sheet must have the name of the offender, his address, his age, the offence committed. Then the charge sheet must also have the name of the complainant, the address of the complainant, then a description of the offence that has been committed, and the offence under which the accused is charged with. Now, with regards to a non-cognizable offence, when the investigation of the case is completed, then what the police officer does is he does not submit a charge sheet, but he submits a police report before the magistrate. So this is basically the procedure with regards to information given to the police officer with regards to cognizable offense and non-cognizable offenses. Now we shall begin discussion with regards to the procedure where complaint is filed directly before the court. As already stated earlier, a complaint can be filed directly before the court by any informant under section 200 of the CRPC. Now, what is the procedure that must be followed when a complaint is filed before the court? Now, the first thing the magistrate must do is examine the complainant and all the witnesses that the complainant brings with him under section 201 CRPC. This examination of the complainant and the witnesses by the magistrate is called examination on solemn affirmation, which we say examination on SA. Now, after the magistrate examines the complainant and his witnesses on solemn affirmation, and if he finds that there is sufficient grounds to proceed against the accused, then what he can do is, if the complaint gives information or discloses commission of a cognizable offense, then he may either send summons to the accused or send a warrant to the accused. Now, if it is of a non-cognizable offense, then the magistrate must issue summons to the accused. Now, while issuing summons under section 204, the magistrate may direct the complainant or should direct the complainant to pay all process fees that is applicable to sending the summons. Now, what happens is, if the magistrate is not satisfied of the commission of an offense by the examination of the complainant and the witnesses under section 201 CRPC, then what he can do is he can direct an inquiry to be conducted under section 202 CRPC. Now, under section 202 CRPC, the magistrate may either take up the inquiry himself or may direct another magistrate to take up the inquiry, or may also direct a police officer or any other officer who will be in the knowledge of the complaint or who will be able to put light in the complaint to investigate the matter. Now, when the magistrate makes investigation or inquiry under section 202 CRPC, a report of the same must be submitted before the magistrate who directs such investigation. The magistrate who is looking into the complaint will then consider the examination or depositions of the examinations under section 201 CRPC, the report of the complaint, and then if he considers that there is sufficient materials to proceed against the accused, then again, if it is a cognizable offense, he may either issue summons or warrant, and if it is a non-cognizable offense, he may issue summons. Now, what is very important under section 201 CRPC is, when the examination of the complainant and the witnesses are taken down in writing, the signature of the complainant and the witnesses must be obtained in the examinations taken in writing. Now, if the magistrate considers the examination under section 201 and under the report under section 202 and considers that there is no offense made out, then what he shall do is he shall dismiss the complaint, and that will be the end of the complaint under section 203 CRPC. Now, it may so happen that the magistrate, the offences that is disclosed in the complaint may be such which is sessions triable. Now, if it is a sessions triable complaint, then a list of witnesses must be given by the complainant. All witnesses must be examined. Now, until and unless all the witnesses are examined, the complaint cannot be, the summons cannot be issued by the magistrate. And another fact that must be kept into mind is, if the accused who is alleged to have committed the offense lives outside the jurisdiction, territorial jurisdiction of the magistrate, then it is absolutely necessary or mandatory that the magistrate sends the matter for investigation or for inquiry under section 202 CRPC. Now, the procedure with regards to complaint filed before court ends with either with the issuance of process under section 204 CRPC or under section 203 CRPC, where the complaint is dismissed. Now, a very important aspect, which is with regards to summons issued by a magistrate, is under section 206 CRPC. Now, here 206 CRPC says it is a notice issued by the magistrate with regards to petty offences. Now, what does section 206 CRPC say? Now, here it says that when there is a disclosure before the magistrate with regards to petty offences, then the magistrate may issue a notice to the complainant saying that you have been alleged to have committed offences with regards to this, and then the fine amount for the said offence is this. That means the amount of fine and the offence must be mentioned in the notice. And he may direct the accused that the accused may either send by post, remit by post the amount of fine and plead guilty, or liberty may be given to the accused that he may appear by any advocate and then plead guilty. Now, if the accused remits by post the said amount, or he appears by an advocate before the magistrate, then if it is remitted by post, then from the money that has been provided by the accused in post, the amount of fine will be deducted and he will be considered to have pled guilty in absence. Or if he appears by an advocate, then the advocate will pay the fine amount as directed by the magistrate. So this concludes in part the procedural aspect of the pre-trial stage in criminal administration. Here we have discussed with regards to complaint filed before the police under section 154, then filed before with regards to cognizable offences, then under section 155 with regards to non-cognizable offences, and before the court with regards to 156(3), and then also before the court under section 200. Now, when the entire procedure with regards to either under section 154, 155 or 200 is completed and everything is ready for trial, then it is absolutely necessary that the magistrate serve all copies with regards to documents or evidence complaint to the accused. This is under section 207 CRPC. Now, once copies are served to the accused under section 207 CRPC, the magistrate can either transfer the case to another magistrate for trial if the offence is triable by the magistrate, or he may try the offence himself, and if the offence is triable by the sessions court, then he will commit the case to the court of sessions, who will then conduct trial with regards to the case. Now, where there are different procedures with regards to trial, which we will be covering in the next session. Now, in this lecture, I have prepared a chart for you which is, in short, the entire process of the lecture where in the chart system. So here, the first part of the chart begins with what is an offence, which is defined in the Penal Code under Section 2N and Section 40, under Section 2N of the CRPC and Section 40 of the Indian Penal Code. Then you have the cognizable offence defined. Then you have the non-cognizable offence. Then you have the summons triable offence, and then the warrant triable offence. So this basically completes our lecture with regards to procedure of criminal administration in the pre-trial stage. Now here, just for information, it is important to note that although the report of the commission of an offence, either under Section 154 or under Section 155, must be given to the magistrate has no power to interfere with the investigation of the case. The entire process of investigation is controlled by the investigating officer or the police authority, and it must be as per the rules of the CRPC. Now, the limited scope of the magistrate in the investigation stage is with regards to bail and with regards to recording of statements of witnesses, either under Section 164 or bail with 437, 438, 439. So this is the limited scope of the magistrate in the pre-trial stage of criminal administration. Now, one aspect that must be remembered is when there is commission of offence, or when information with regards to commission of offence is given to the magistrate under Section 376 or 354 or any sexual offences, then it is also the duty of the police officer to get the victim examined by any medical practitioner in a government establishment within 24 hours of the receipt of the information. And if a government establishment medical officer is not available, then by any other medical officer practicing medicine, but he must have a registration number, or he must be a registered medical practitioner, and then he may be examined, the victim may be examined by him. A report of this examination must again be included in the CD. So with this, we come to the conclusion of this lecture with regards to procedure with regards to criminal administration in the pre-trial stage.